Hi, I'm Mike Evans from the Australian Security Academy, and over the last 20 years I've been amazing my students with my investigation stories.
It's a head-on between a Mini and a Vauxhall.
Today we're going to look at cross-examination and giving evidence in court.
In summing up, it's the Constitution, it's Mabo, it's justice, it's law, it's the vibe, and no, that's it, it's the vibe. I rest my case.
That was sensational.
Counsel for the respondent.
Your Honour, I don't wish to waste any more of your time.
One of the great movies in Australian history, lots of great court scenes, and it is about going to court. The Castle, starring Michael Caton. Really great movie. Welcome to our Australian Security Academy presentation on giving evidence in court. Today we're going to have a look at you, the investigator, when you go to court, how it's going to come together, how it all happens, what goes on, how to conduct yourself, and how to survive cross-examination. Now, one of the things people always say to me is, will I go to court and how often will I go to court? Well, back in the day, I used to go to court on every investigation I did in the beginning of my investigation career, and I think I attended court some 35 times. But it's absolutely no point listening to me. What I did in the past, it doesn't count now.
I'm living in the 70s. I'm living in the 70s. I'm living in the 70s. I'm living in the 70s.
Well, those days are gone. We need to see how it works with a contemporary investigator, and have they gone to court in recent times. So here's one we've prepared earlier. Alex, can you tell us, have you been asked to go to court recently, and how did that come about?
Yeah, I have. I had what was a really small job, and this is often the way it happens. It's always the smaller jobs. I got told on a Friday afternoon, last minute, that I was to go take some photographs of a place. Later on, I was to find out that it was a very serious matter, and the photographs that I took were actually really important. It was an Australia-wide job of a certain type of business, and I had to go around. I didn't know what to take photographs of. The instructions were a little bit blurry, so I just basically took photographs of absolutely everything, which turned out to be a really good thing that I did. But I did get asked to go to court over it.
Alex, can you tell us, what court did they ask you to go to?
It was funny, when I was getting the JP to sign off on some of the documents, some of the copies that I'd made, they stopped and looked up and said, "This is very serious," and it was the High Court in Victoria.
That's the highest court of Australia that you were asked to go to for the smallest job you've possibly ever been asked to do in your career. So I say this to students time and time again, it's not the $5 million matter that you will go to court on, it's that one that seemingly doesn't matter. But if you end up in the High Court, you're going to be there giving evidence in chief, and being cross-examined in front of 3 magistrates wearing red on that bench. So that is a very big ask for an investigator. And I've seen investigators who've had their licence for a week end up in similar circumstances. So Alex, thank you very much for coming along. I really appreciate you letting our students know that it can happen in 2020. Sometimes they just don't settle, they will take it to court. So thanks for coming in. We'll see you in another program later on.
Anytime. Thank you.
So, you just heard it from a contemporary investigator. Investigators today, it doesn't matter whether you're a government investigator or a private investigator, you may end up in court on a matter. It might be minor, it could be important, it could be very serious or expensive. And this one, Alex just explained to us, was a very short job. It was to take some photographs, and he was summoned to go to the High Court of Australia over it, and that happened this year. There were some other investigators around Australia who ended up on the same job, and the same thing happened to them as well. So you must be prepared as an investigator to go to court. Now, when you go to court, there are three parts to the process. You go to the court, you wait outside, you've been summoned to be there, you've got an email, a letter, a phone call, whatever. You go to that particular court and you wait outside until your name is called to go in and give evidence. Now, there are three parts to that evidence giving process. The first part is evidence in chief, the second part is cross-examination, and the third part is re-examination. After re-examination, they invite you to stay or you can leave. It's up to you, but you're given that invitation, that choice by the magistrate. So that's what happens. So you go to court, you wait outside. Now, the message I have to get to you, and I have to get it across to all my students, is just because you're an honest, law-abiding person, nobody's going to believe you just because of that. Right, so when you go into court, there is going to be doubt cast on your credibility and doubt cast on your evidence by the opposing side. That's our system. It's two sides fighting, two sides battling on with each other. So you go to court at the appointed time. Now, if I could give you one tip about giving evidence in court, if you know you're going to be at the Gas Tribunal next Thursday morning at 11 o'clock, which is, 9 days away or something, pop along to the Gas Tribunal this week on Thursday at 10:30 and go and watch what happens in that courtroom. You can go into any courtroom in Australia, in any court, as long as above the door it says open. That's our system. Now, you can't go to the family court or the children's court. No, that's not going to happen. But every other court, if it says open above the door, you can walk in and you can watch. That's our legal system in action. So you can pop along and get familiar with it. And my firmest advice to you, to help you to understand the process, is go and do that. Go and see it beforehand. You'll be more relaxed about it that way. Prior to giving evidence, you may be asked by the barrister who's going to take your evidence in chief. That's the barrister that's on your side. You may be asked to meet with that barrister 2 weeks or a week before the court date. And this will make you feel very important. You'll go along and you'll meet the barrister in chambers, and you'll be waiting in their boardroom, and you'll be looking around, and there'll be all these oil paintings of magistrates and judges, and the ladies look absolutely stunning with these great big life-size oil paintings, and the men look, grumpy old guys in wigs and stuff. And you look at that's quite fascinating. You're actually tempted to pull your phone out and take some photos, but don't do that. All right, so you wait in that boardroom, and the barrister will come in, and don't expect this to be a very big meeting. These people are very busy. They've got a lot of cases on. They can earn up to $8,000 a day. So they might just say to you, okay, Mr. Evans, are you all prepared for next week? And I'll go, yes. And they'll go, have you got all your statements and all your photographs? And I'll go, yes. And they'll go, thanks, see you there at 11 o'clock next week. That's very short, very quick, and that's happened. These never really are lengthy pre-court meetings, so don't think you're going to be coached or helped in any way, really. You're a professional, you're a trained professional, you've done your course, you know how to take statements properly. In your course, you were obliterated on your first statement because it wasn't good enough. So you now know the standard that's required for a statement to get to court. So you're going there as a professional trained in taking statements, so you're going to be confident. In your course, you were obliterated on your first report. There was opinions, and there was spelling mistakes, and there was missing parts, and that was all fixed up, and you had to do it again. Now you're going to court as a professional who's trained and experienced in that, so you've got to be confident. But the court will not believe you just because you're a trained professional who's confident, who's honest. You've got to be good at giving your evidence. I'll come to that in a minute. So you go and you wait outside the court. Now, it's very important when you're waiting outside the court that you do not discuss the court case with anybody else or discuss about the case, what's going to happen inside. It's really important. You're going to go there and there might be 2 other investigators from your workplace who are involved in the same investigation, or a couple of surveillance operatives from your workplace, and you might be tempted to talk about this case because it was 3 years ago that you did it. You haven't seen those other investigators for a couple of years. Be very careful about that. Outside the court, do not discuss it. Now, I have had countless people who've had that experience where they've talked about it outside the court. They've gone in and they've been sworn in, and that innocuous person who was just sitting there reading a book or some documents walked into the court, went up to the opposing barrister and whispered in their ear about the conversation that was had outside. Now, under cross-examination, that's going to be an agonising, uncomfortable hour over what that 20-word conversation was. And you'll be accused of colluding, and they'll be dramatic about it. So avoid talking about it. Talk about the footy, talk about the weather, but don't talk about the court case. So you're ready to go into court. What they do is they come outside and they call your name. And the court orderly is a really nice person, and they're really efficient and they're really thorough, and they go, Mr. Evans, witness. That's what they call you. They call you witness because you're a witness. You go into court as a witness. They say, witness, okay, when you get into the witness box, what you've got to do is you put your right hand on this and you raise your left hand and you say, I swear to tell the truth, the whole truth and nothing but the truth. Have you got that, witness? And you go, yes, 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 yes. So you walk in behind that person and you get up into the witness box and you're standing there, and you didn't take my advice about going to the court a week earlier and looking at how it works in the proceedings. And you look up at the magistrate's bench, and the magistrate's sitting there, in a red sort of like cape with a wig on, and in front of the magistrate, there's on the left-hand side and right-hand side, there's 3 solicitors and a barrister and law books stacked up to the ceiling, and you're there watching and you're thinking, oh my God, this is pretty serious. And you look up at the coat of arms behind the magistrate, and it's an emu and a kangaroo, and you think, oh wow, Mike Evans said in our court evidence presentation, they're the only 2 animals in the world that can't walk backwards. And you're thinking about that, and you look over into the corner and there's that lady staring into space, typing into one of those little machines. That's the only thing that's real when you see a program on courts on TV or in the movies. She's the actually only real thing that actually happens in court. So you see all that and you're absolutely intimidated and you forgot what you got to say. It's okay. They have a little card and they slip that to you because everybody else forgets as well because they're so intimidated. It's designed to intimidate you. That's what it's for. So basically you go, I swear to tell the truth, the whole truth and nothing but the truth. But you do not say it, I swear to tell the truth, the whole truth and nothing but the truth. You say it in a big loud voice. I swear to tell the truth, the whole truth and nothing but the truth. You let that court know that you're there as a professional to be listened to as a professional. You're there to do business, you've done this investigation and you're there to follow it through. You're not afraid of it, there's nothing that you've done wrong, So you be very confident when you're being sworn in. It puts the other side on notice. Now that first part that comes along is the evidence in chief. This is where the barrister, who you met last week in that short meeting in their chambers with all those people with oil paintings around the room, this is where that barrister, she talks you through what she wants to come out. Now, she's been researching this case, she's read the statements, she's read all the reports, she's looked at the photographs and the measurements, and she says to you, witness, did you take a photo marked 1A? And you reply, yes. And did you take that photograph on such and such a date? And you reply, yes. And witness, did you take a statement from the cleaning manager, Mrs. Smythe, on such and such a date? And you say yes. And then the barrister will say, and in that statement, Miss Smythe said blah, 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 blah. Is that correct, witness? And you'll reply yes. During cross-examination, you're led through what they want to come out. And they're building a case, and that case is they're conducted in, not cross-exam, evidence in chief, sorry, in evidence in chief. This is live. You can't go back and edit out that mistake. So during evidence in chief, they lead you through what they want to come out. I'm in barrister mode, thinking ahead. So that's what happens in evidence in chief. It's really friendly. You answer the question, you don't have to elaborate on anything. If they want more information, they will ask you for it, and they lead you through the evidence they want to come out. It's as simple as that. And they do that with every witness that goes in, and you're doing it from the part that they're interested in with you. So it's photographs, statements, measurements, video, research you did, conversations you had, that sort of thing. The next part, when they're finished, they will say no further questions, Your Honour. And the magistrate then will allow cross-examination. Now, giving evidence in chief is quite pleasant, it's quite friendly, it's conversational, and it's quite nice. Do not expect cross-examination to help you or your case. Cross-examination is like having a bush stick jammed up your backside and twisted. That's what it's like. It is an all-out attack on you, the witness, by the defence counsel defending their client. And they're going to do a time and event line on your investigation. They've got a copy of that in the discovery process, and they've got a copy of that, and they're going to attack you on spelling mistakes in your statements or opinions in your statements, which is why during the class I was so Nazi on you about there being a missing full stop or not a jurat on the end, or someone mentioned and you didn't put their name, address and contact details in. I did that in your class to protect you when you get into court, so it'd be thorough and you couldn't be attacked on that. Well, maybe, you had a bad day and you slipped up on one or two. So if they can find a grammatical error or a spelling mistake, and that's all they've got, that's what they will harp on under cross-examination to attack your credibility. They'll ask you, are you professional and proficient? And you will reply, yes. And they'll say, well, in paragraph 3, there's a spelling mistake here. Did you put that spelling mistake in there as a lie to mislead this court? And you've got to go, no. They'll say, did you put that spelling mistake in here as a lie to impress this court? And you'll go, no. So they'll do that. If all they've got in their case is grammatical errors and spelling mistakes, they'll look for that in your reports, they'll look for that in your statements, they'll look for any weakness to attack you on. And they're looking at how you respond. And if your responses are meagre or weak, or you're a bit of a mouse and they sense that, the words that are going to haunt you for the rest of your life when you think back on that day of cross-examination are not good enough. And they'll get right in your face, and they've got big eyebrows just like John Howard, and that's just the ladies. And they will say, not good enough, and they will shout it out. And you'll think, oh my God, this barrister on the other side who just earns $8,000 a day told me I'm not good enough. oh my dear, oh dear, that's awful. And they're trying to distract you because they've got a whole lot of questions to ask you. So don't fall for it. Just listen to what they say and listen to the questions that they ask you. Under cross-examination, as much as possible, you limit your answers to 3 things. Yes, no, and I don't know. Now, if they ask you, witness, what is your name? You have to say, my name is Michael Evans. If they ask you, witness, what is your occupation? You have to say, I am a licensed private investigator. Okay? But if they ask you questions other than that, just reply yes, no, or I don't know. They will say to you something like this: witness, are you professional and proficient? And you will reply yes. Will your evidence today be true and correct? And you'll reply yes. And they will say to you, will your evidence today be in accordance with the rules of evidence? What would you reply to that? You're there as a professional. They've just asked you a legal question. You don't have to know the law. You haven't got a law degree. What are you going to reply when they ask you, is your evidence today going to be in accordance with the rules of evidence? All your workmates are sitting in the front row. They're watching. If you say yes, the next question is going to be, witness, what are the rules of evidence? Now, if it's 2 years since you've done your course and you didn't think that was important and it's in your course and you've forgotten, you are now going to go through 3/4 of an hour agonising questions about why you don't know the rules of evidence and why you should have known that. And they're going to be bang question, bang question, bang question on your credibility, on your qualifications, but you said you knew the rules of evidence and you don't know the rules of evidence. Why did you say that? Did you say that as a lie to mislead this court? Did you say that as a lie to impress this court? All I want to know is why. So they will do that to you. They've trapped you by just asking you that. Now, in your course, you can remember when you think back, because you can't remember under pressure here, that the rules of evidence were simply, well, is the evidence relevant? Was it legally obtained? And when you add those two together, therefore it's admissible. Now, you've completely forgotten that because of the emu and the people in the wigs and the coat of arms and the kangaroo and this law book stacked up to the ceiling that's all designed to intimidate you. You've fallen apart already, and we're only been there for four minutes under cross-examination. So be aware of that. How to avoid that? When they ask you, witness, will your evidence today be in accordance with the rules of evidence? Your answer is answer number 3. Remember the first answer, yes. The second answer, no. The third answer is, I don't know. You don't have to know the rules of evidence. Now, if this gets excruciatingly painful, the magistrate may interrupt and say, look, Mr. Barrister, we've had enough of the rules of evidence, could you just move on? And then later on in evidence in chief, if your barrister's paying attention, when they come back out, and as the Australian Security Academy training manager Pat Flynn says, they come out at re-examination, sorry, I'm messing this up, it's live. When they come out at re-examination, they say, Mr. Evans, when you were asked about the rules of evidence, you don't have to know the rules of evidence, do you? And I'll go, no. And they'll say, lawyers need to know that, don't they? And I'll go, yes. So they're putting a band-aid on a gaping wound, as according to Pat Flynn, the training manager of Australian Security Academy, fixing up my mess under cross-examination. Now, they won't just ask you about that. They're looking for you to be mug enough to answer questions beyond your scope. And if they can get you answering questions beyond your scope of your knowledge, you're going to look ridiculous in front of a barrister or a magistrate. You're going to look ridiculous in front of a jury, but they will keep doing it just to make you look ridiculous. But if you give them the correct answer, I don't know, they'll give up on it really quickly. they'll say things to you like, "Are you professional and proficient?" And you'll go, "Yes." "Is your evidence today going to be true and correct?" And you will say, "Yes." And they'll say, "Is your evidence today going to be in accordance with the Evidence Act 1984? Again, it's answer number 3. I don't know. Because as soon as you say yes, they'll say, "Are you familiar with the Evidence Act 1984? You're silly enough to go yes again because you think, "I have to be professional, I have to know that because this barrister's told me he earns $8,000 a day and they think it's important, so I've said yes." They're going to say to you, "What does paragraph 3, section 24 of the Evidence Act 1984 say?" And you'll be, "I don't know." And they'll say, "Well, why did you say you did know? Do you want me to replay the tape?" And they will go on and on about, you don't know the rules of evidence. You don't know the Evidence Act 1984. Now, they've just made the Evidence Act 1984 up. It doesn't even exist. And you've fallen for their trap. So be aware under cross-examination that this is going to happen. Your credibility is going to be attacked. Don't think you have to know how a building was built, you know, what an architect does, that sort of thing, other than what you've got in your statements or what you've been told by the engineers in their statements. That's all you have to know. You don't have to know anything else. So under cross-examination, they are going to take you to a place they want to take you to, and you've got to be on your guard to be ready for that. They will hit you with rapid-fire questions. Where were you standing when you took this statement? Well, sorry, where were you sitting? Where was the witness sitting? How long did this statement take? You don't have to, under cross-examination, go at the pace they go. When they ask you a question, think about it. Yeah. Yes. You control the pace. It's like when you were in primary school and you played softball or baseball. If the pitcher threw a ball at you and it was below your knee, you didn't have to swing at it because it's one of those sort of like free things you get to walk a base if they throw one above your shoulders and two below your knee. So you don't have to swing at the ones that are wide. Let them go through to the keeper, right? So when they ask you these questions and they're going really fast and they're in your face and demanding yes and no answers and it's coming at you rapid fire, just slow down. Control the pace. Don't play the game they want you to play. Be really aware of that. They want you not having time to think, so you'll give a confused or a conflicting answer to what one of the other witnesses said or to what you said 5 minutes ago. So don't do it. If they continue to do it, go slower. No. Yes. The really interesting thing and the important thing that you must understand, on television and in movies where you see them go, "I object, Your Honour." That's the barrister on your side in movies and TV. It doesn't happen in the real world. When you go to court for real in Australia, you're sitting there getting an absolute hammering with someone going question after question after question. No one says, "I object." You're the professional. You got paid to do this. You're the trained, qualified professional. They expect you to be able to handle this type of situation. Now, nobody warns you that this is going to happen. So be warned, cross-examination, it's a very, very hard slog. Your credibility is being attacked on lots of different fronts. Now, rapid-fire questions is one way they do it. Another thing they like to do, and you're very experienced at this, is they'll ask you a question. "When did you take that statement?" And you'll go, "Last Thursday." Then they'll do this. Now, if you're a mug, right, you'll go, "Last Thursday afternoon." And if you're a real mug, you'll go, at 4:15. In the tea room at the workplace. And you'll be gibbering on like a 5-year-old. It's staring at you to elicit more information to make you look like a complete fool. Now, you don't volunteer extra information, you make them work for it. If they want an answer to a question, make them ask the question, you don't give it to them. So, when they stare at you, you played this game with your brothers and sisters on long car rides, or your cousins, or your next door neighbours. You played this game in the back of the car for them. The first one to talk loses. And you were really good at it. You kicked butt in the back of the car when you were 7 with other kids. Why should you sucker for it now that you're a 25-year-old, 30-year-old adult? Don't. So if they want to stare at you to elicit more information, they're doing that to see how easily intimidated you are. And the more easily intimidated you are, and the more you start blabbing on, the more information they get that's good for their case, and you look totally unprofessional. So don't do that. They'll do other things. They'll pronounce your name wrong. So I've had my name now for 60 plus years, okay? It was given to me on the day I was born, I believe. I'm used to responding to it. When I'm in trouble, my mother calls me Michael. Everybody else calls me Mike. That's it. But they'll say, Mark, can you tell us about taking this statement or examining this scene? Now, while they do that under cross-examination is to make me think, who are they talking to? My name's Michael. While I'm figuring this out, because I'm a dumb idiot, they've asked me another 3 questions I haven't responded to, and I've got all confused and lost. And suddenly, I'm unprofessionally answering things I don't know anything about. So be aware of it. They've got tactics to confuse you, tactics to, they'll fluster you. So they will do theatrical dramatics. They'll be holding in their hand a bunch of documents. And you'll be in the witness box and they'll have these documents and they'll be banging them and they'll tear them up and dramatically throw them over their head. And you'll be sitting there watching, this lady earns $8,000 a day. She's acting like a 2-year-old. It's just to fluster you. It's just to confuse you. Now you think, the magistrate up there is letting this happen. Well, yes, the magistrate is letting this happen, right? The magistrate used to be a barrister herself. She used to do it too. It's the way our system goes. If it gets ridiculous, the magistrate will interfere and say, look, Miss Barrister, I think we've had enough of that point. Can we move on, please? And thank you for the theatrics. All right, so it's a game. It's what they're paid to do. They're paid to discredit you. They're paid to confuse you. And they're paid to use a range of tactics. Now, they know that you're a trained witness with qualifications. You're expecting this, all right? So they really expect all witnesses to be trained like that, but if they can get away with it and push some buttons and win on you, but they can't win on the next one or the next witness, they've got that little bit of doubt cast in what's going on. And if this is a criminal trial and it's beyond a reasonable doubt, and you're the witness that caves in and gets confused and messes it all up, then you're the weak link in their program. If they smell that weak link, they're coming after you. So, you control the pace. Don't get sucked in to answering questions that you have no idea about. Stick with yes, no, and I don't know under cross-examination as much as possible. Okay, so as much as possible, do that. As I said, they will yell at you, not good enough. And that will come back and haunt you every time you think about the time you gave evidence in court. Now, it's worse because all your workmates are in the front row watching and they're laughing. At least when it happened to me, they didn't have Facebook to rub it in extra for the next 5 years. So be prepared for that. Now, after cross-examination, let's say you survive it, and people do, it happens every day, all right? They have the re-examination process. That original barrister comes back out and says, witness, do you have a law degree? And you go, no. And I say, witness, is it a requirement that you know the Evidence Act, whatever year, in any state, in any country, anywhere? And you go, no. Right? So you're not a trained lawyer, witness. You go, no, I'm not. Are you supposed to be witness? No, I'm not. Right. And they clear that up. And if you got confused and it was during the cross-examination process and you said you were 50 metres away when you saw it, they'll say you were 500 metres away, and you'll think after question really rapidly, and you answer yes. They'll say, under re-examination, they'll say, where you said you were 500 metres away, you were only 50 metres away, weren't you, witness? And you go, yes, that's correct. And they clear up as many mistakes as they possibly can. Let's hope that there's not a lot of them. That's their role. Now, at the end of re-examination, they will say, that's all I have, Your Honour. And the magistrate will say, witness, you are welcome to stay and watch proceedings, or you can leave. Usually, you'll just leave because you just want to get out of there. Now, I was in the witness box one day. I was there probably less than 4 minutes, and the barrister came out under cross-examination and she got stuck into me viciously. I mean, she attacked me on everything. Less than 4 minutes I was there, and there was no re-examination. There wasn't anything messed up. So they said, do you want to leave? And I said, yes. So I walked out of the court. I couldn't remember my name. I couldn't remember where I parked my car. Now, luckily, when I went to court in Brisbane back in those days, my wife would come with me and she'd go shopping in town while I was on the fringe of the city, and she'd do that while I was at court and have a bit of lunch, that sort of thing. So I rang her up and I said, sweetheart, what's my name? She said, your name's Michael. She's used to me and what I'm like. I said, where did I park the car? She said, which court are you in? I said, the Workers' Compensation Tribunal. She said, you parked up by the church. And then I remembered where the car was. So I went up and got it, and then I went up and picked my wife up. That's how, 4 minutes made me forget all that. Seriously, it's pretty tough. So I went back to the same court 3 months later on a different matter. And I'm being sworn in. I swear to tell the truth, the whole truth, and I looked up at the bench. The person who's now the magistrate was the barrister who cross-examined me 3 months ago. And I thought, oh no, this is going to be terrible. And so I did my evidence in chief. Then another lady came out and she started cross-examining me, and she's into me about this and into me about that. Spelling mistake, grammatical error, opinion. There weren't any, but she's making these up because she's got to argue the toss about something. The magistrate on the bench kept going, wait a minute, I want to hear what Mr. Evans has got to say. Give Mr. Evans a chance. Let me hear what Mr. Evans says about that. And I'm there thinking, lady, 3 months ago, you're doing exactly the same thing. Now, to them, it's just a game. It's nothing personal. Believe me, cross-examination's personal when you're under it. That's what it's for. But it's nothing. That's what they do. That's how system works. They test you out to see how you handle pressure. Now, if they didn't do that, innocent people would be going to jail. Witnesses would be making things up and lying about things in court. So the evidence that people have has got to be tested. It's got to be made sure that it's accurate, that it's correct, that it was handled properly. It wasn't just planted there by people. So that's what the cross-examination process is all about. And if you were accused of something, you would want to be defended to that degree as well. So understand it's part of the game. At the end of the day, those barristers all go out and they have a cup of tea and a scone together. That's what they do. So keep that in mind. Going to court, it's part of what you do. You heard a licensed private investigator today say, on the smallest job he's had in recent times, he's been requested to go to the High Court. So it can happen. You don't do a half-baked investigation. You don't do a half-baked statement. You don't leave vagueness and ambiguity in a statement because it could be tested in court. And I need you to understand that. And if it's going to be tested in court under cross-examination, and you look like a complete fool with all this incorrect information, vagueness and ambiguity, the magistrates, when they go and have that cup of tea and scone, they go, well, witness Evans, his statement was really lacking. The other investigators, their statements were pretty good. He wasn't very good. And then that magistrate will go and have a conference next week, and they'll be talking about poor witnesses and bias, and they'll say, oh, I had a witness recently, his name was Evans, and blah, 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 blah. So the next time you go back to that tribunal or court they're presiding over, they're going to have great difficulty believing you. Now, I've actually seen this happen in a court. Magistrates are not fools, they've been around. There was a uniformed police officer in the witness box, and he was saying, and yes, I asked the defendant this question, and she replied, blah, blah, blah. And then I asked this question, and she replied, blah, blah, blah. And the magistrate said, officer, how can you remember what she replied and what you asked? This was some 14 months ago. And the police officer said, because I made notes in my notebook, Your Honour. Now, this magistrate, she read him like a book. She said, officer, how far away do you live? Where do you keep your notes? He said, at home, Your Honour. She said, how far away do you live? He said, oh, probably 25 minutes from here, Your Honour. She said, you don't have your notes with you, you've left them at home, is that correct? And he said, yes, that's correct, that's what I said earlier, Your Honour. I said, okay, what we'll do is we'll recess this court for an hour, give you a chance to go home, get those notes, and come back here with them, and we will bring them up here to the bench, and I will see them. And he sunk down in his chair, and his face went red, and his head went down, and she said, officer, you didn't make any notes, did you? And he said, no, Your Honour. Now, he just admitted to perjury in court. This is a very serious matter. Very, very serious matter. She didn't charge him with anything or anything like that, but she would have been straight onto the email when that day was over and told all her associate magistrates, whenever officer such and such comes into your court, this is what he just did in mine. So his integrity is wrecked for every time he goes and gives evidence from that day forward. How powerful is the court system? It's extremely powerful. And if you commit perjury or you're smart and showing off in court, they will bring you into line very quickly. I had a surveillance investigation where I had 3 hours film of a man who couldn't bend, couldn't lift, couldn't carry, his back was stuffed, he couldn't do any of these things in his claim, and it was a result of a work for the dole program where he reckoned he was injured in that. And I showed the surveillance video for 3 hours of him in court, and basically he'd been examined by doctors and specialists, and this video was accepted by the court. And at the end of it all, the magistrate had weighed it all up, and she said, okay, all right, Mr. Smith, I am charged for the crime of insurance fraud. I am sentencing you to 3 months in Risdon prison. Have you got anything to say, Mr. Smith? Don't say anything. But Mr. Smith said, yes, Your Honour. She said, what's that, Mr. Smith? He said, Your Honour, I can do 3 months in Risdon prison standing on my head. She looked back at him and said, thank you, Mr. Smith. I'll give you an extra 3 months in there to help you get back on your feet. Take him away 6 months. That's pretty powerful. For the crime of insurance fraud, what is the maximum penalty in Australia? The maximum penalty in Australia for insurance fraud is 14 years in jail. That's what you get for murder. So you ring up the insurance company and say, look, I just lost my Nintendo or whatever, it's worth $5,000. and you just want to buy a new one, you never lost it in the first place, and they find out about it and you get charged with insurance fraud, you're facing 14 years in jail. Now you can see this in your local court. My local court is Southport Court in the Gold Coast in Queensland. And where these ones go to trial, basically it's called the overnight arrest court, where they just handle bunches and bunches of matters like a supermarket. They don't even have shoplifting, you just get a ticket, because there's so much shoplifting you don't even go to court on it anymore, you just get an instant ticket. But matters where someone, a young apprentice, has bought a brand new car because it was his first job, first time he ever had money, and he's 2 years into that car loan, the value of the car's come down, the insurance has gone up, and he can't afford it, he's got to pay his rent, he's got to pay his meals, and this massive car repayments crippling him, and he listens to his mates who say, just take it up the bush and burn it and the insurance will cover it. So he thinks, all right, I'll do that. So they'll go and do that, or do something really stupid like it's a moment of silliness. They're not professional criminals, they just do a stupid thing. Now, through the investigation, they found out in the insurance company that this person, their car did get burnt, but it was never stolen. The owner of the vehicle drove it up into the bush, poured fuel in it, lit it, it was destroyed, right? Completely destroyed. And later on, this person confessed to it, so they've gone to court. And they end up in the overnight arrest court at Southport on the Gold Coast. Everyone in that court, we're talking very hot, humid weather, everyone that goes to that court, they wear board shorts, caps, singlets covered in spilt hamburger and pie and sauce, and you know, they're fined and sentenced and dealt with. They're not wearing shoes, and there's 50 a day are done. When these people that are caught with insurance fraud, they front up to that same court, they're wearing suits. They have a solicitor with them, and when the magistrate says to them, stand up for sentencing, you watch them stand up next to the solicitor and you can see them visibly shaking, because they know they are facing 14 years in jail for insurance fraud. Now, I'm not defending insurance companies, I'm just saying that's the way it is. And that magistrate can make that call. Now, hopefully the solicitor will say, oh, Your Honour, this person's from a good family, you know, he got his apprenticeship, you know, he supported his mum who was ill, looked after his little sisters and brothers, and he goes to Sunday school, and he's been volunteering at the animal shelter, and he's very sorry for he realises what he's done was wrong, and blah blah blah. He's been paying it back to the insurance company, and he hasn't lost his job as a result of this. His mum and dad are here in court today to support him, and the magistrate will take all that into account, and they'll say, all right, pay it back. I won't record a conviction on this case. I believe it was a stupid mistake, but you'll be paying that back to the insurance company for the next 25 years at that amount. And that's what they do. So, you know, very few people are going to get 14 years for insurance fraud, but be aware of the seriousness. You see those people shaking when they stand up, you realise just how bad that is. Now, the important thing here is you see in action in the court what you do as a private investigator or a government investigator. Nothing can happen without a day, a date, and a time and a place. So when someone goes to court and there's no argument, they just confess and they say, I did it. What happens is the magistrate says, all right, constable, can you read out what happened? And the first thing the police constable does in uniform goes, they go, on this day, date and time and place, Joe Bloggs drove his car up the bush and poured fuel on it and burnt it and destroyed it. They go through what was done, and you see what actually you investigate in action. Whenever you interview someone, take a statement from them or look at the circumstances. It happened a day, date, place and time, and that's what the courts want to know. I volunteer as a teacher in an at-risk youth program on the Gold Coast. These kids are the worst of the worst kids. They've got to be thrown out of 3 high schools, and they've got to be former drug addicts and prostitutes, and they're all under 16 years of age. And to get into this program, they have to be drug free, and they have to be applying for work. And if they do that, they get the equivalent of the dole. Now, these kids have not come from happy backgrounds. It's been very difficult for them. They're on their own. The accommodation is organised initially to help them out, to get them back on their feet. And I was in court one day watching, and one of my kids from one of those programs came out. Now, this kid was stone cold motherless, the worst kid I'd ever seen. He was absolute nothing likeable or good about this kid. And he comes out and he's put in the witness box, he's in handcuffs. And I'm there watching with great interest, because I was just there watching on that day, with a class actually. And he pled guilty to what he'd done. And he'd stolen 16 vehicles, motor vehicles. He carried around with him a worn down key. And he just opened the car with a worn down key and start the car with a worn down key. That's what motor vehicle thieves do. So he'd done that, and he just spent 3 years in prison for it. Now, as soon as he's walked out of prison because he served his time, the police are waiting for him. They got him there for another 3 stolen vehicles, because his fingerprints were found later on other vehicles. They got him for another 3. So instantly they dragged him back into court in handcuffs, and he's pled guilty to it. And the defence solicitor has to say something nice about him, and there's nothing nice you can say. But he did his best. And the defence solicitor said, look, my client, at the earliest opportunity, Your Honour, has pled guilty to these extra 3 cars being stolen. He can't remember doing it. While he was serving his 3 years in the correctional facility, he caught meningococcal, the kissing disease. So he caught meningococcal, and he was in a coma for 3 months. And that's a good thing. And the whole court's there going, what? How can meningococcal being in a coma for 3 months be a good thing? And the defence solicitor goes on, it's a good thing, Your Honour, because it cured him of his heroin habit. So the magistrate took all that into account. Time served 3 years. He'd been waiting to get to this part for 3 days, so she let him off for it. So they're very fair. Courts are overly fair. So what I want you to take away from today, you're the professional, you're trained, you're qualified, take it seriously, go and visit the court beforehand, enjoy the experience, answer yes, no, and I don't know, stick to the truth, and you'll never hear those words, not good enough. We'll leave our final part today to the same people that gave us our introduction.
On just terms. That's what this is all about. Being just. They want to pay home in the house. But they're taking away more than that. So much. You can buy a house. But you can't acquire a home. You can't pay for it. And you're just shortchanging people if you try. I can't speak for those words. But I'll bet within the phrase on just terms they hoped would stop anyone shortchanging someone down. We won.
A win in court is very rare. There are tribunals, there are courts, there are systems in place to prevent going to court where they mediate. It's more likely to be settled and mediated today before you go to court, but the one matter you think small is just a Sunday afternoon job for an hour, ends up in the High Court of Australia. You've been warned. So be prepared for it, take it professionally, enjoy your work as an investigator. I'm Mike Evans from the Australian Security Academy. Thanks for watching.